the summons and complaint within 120 days, the court had a couple of options, one of which at the time would have been that they've had to dismiss the case. They didn't do that. So I guess I don't know if it went back to North Carolina or not, but somehow it appeared in Hillsborough County. And I believe the date is May 15th is when this case began in Hillsborough County. In fact, May 15th, 1995. And we can look at the docket. You have a copy of the docket as well, correct?
I'm reviewing the docket. I think the recitation of facts and the 321-24 order are, they're easy enough to follow. I don't know that there's anything that was misstated there unless you have a point of clarification.
Well, a point of clarification is I guess we could stipulate that the record also shows that in between May 15th, 1995 and June 1st, 1999, when there's an alleged service of process, there was no record activity of a extension of time to serve by the court, or even a showing of good cause by, I believe at the time would be Manish and McIntosh, who were the representatives for the state of Florida. Can we stipulate to those sets of facts as well?
Are you asking me? Because I'm not stipulating anything, sir. I will take judicial notice of the record.
Take judicial notice of the record. Good, there we go. Mandatory judicial notice of the record, in fact, pursuant to Chapter 90 of the Florida statutes. And the record shows that it was initiated in 1995. It wasn't served until 1999, which would be beyond the 120 days for service of process. The law demanded, and I'll go to Gaines versus Placilla, and we can go to 634 SO2D 711, 0, where it says that an action be dismissed without prejudice where service is not made upon a defendant within 120 days after the initial pleading where there is no showing of good cause for the delay. And as we look at the clerk's record, we see that that did not happen. So I'll just say that the court erred in not dismissing the case at that point. We go further. Because it doesn't show that there was a good cause for failure to serve the defendant within 120 days, Rule 1.070, which mirrors 12.070, states that the trial court should have dismissed the case. And we go to that Patterson versus Lowenstein, you have that as well. And I think that most of these are pretty clear. And back to the issue of res judicata, I want to cite the Florida Department of Transportation versus Giuliano, and that's 801 SO2D 101/105, that the issue had to be litigated and determined. And to date, there's been no definitive ruling as to whether or not the court's position is that it had subject matter jurisdiction and definitely didn't have personal jurisdiction.